Spectrum TV, broadening your horizon.
Nigerian which is the only one allowed by cross them. Our governors have to share police power with the president as stipulated by the constitution. We do not have a federal government police force. We have the Nigeria police force, which shall be administered, organized, and supervised by the Nigerian police force.
No, my lord, I want to say something. Here. Perhaps it might also enlarge the scope of people who should be invited here for examination. My lord, if we cannot find those who literally murdered Abiola, who are those people who could be said to be the beneficiaries of the death of Abiola?
Rogers has linked you with some of the killings he did.
He never did.
He linked you with the attempted murder of Hebrew.
He did not.
My lord, the matters council is leading the evidence in our matters.
Is this an adversary proceeding?
It's not, my lord, but we can't be talking about cases which are in court.
Is this an adversary proceeding?
It's not, my lord. These cases are in court, my lord. I'm just reminding your lordship.
My lord, sorry, my lord, I think I'll be in course of
Legally Speaking, a program that deals with legal issues and questions we face as citizens of this amazing country, Nigeria. Legally Speaking. Join us every
Friday from 5 p.m. to 6 p.m.
for Legally Speaking.
Hello, good evening. You are to Legally Speaking on Spectrum TV, channel 136 Startimes, and Planet Radio 101.1 FM. My name is Anthony Ebuk. Sorry we couldn't be with you last week, but we are here. Now, today's episode, we'll be looking at two very burning issues, especially on the social media. One is the conviction of Mr. Uduak Frank Akpan yesterday for the murder of one Inibe Umoren. The conviction is the court sentenced him to death by hanging and life imprisonment for rape. Now, that's one thing that we're going to consider today as the first topic. And secondly, we'll be considering the issue of the conviction and for contempt of court of Learned Counsel Inibe Effiong. I might be having a guest join us. We are now, I have Sebastian Udo. Sebastian Udo is a legal practitioner here in Uyo. He'll be joining us to discuss this and more. In the course of the program, we might have another guest join us. Sebastian, you're welcome to the program.
Thank you so much, my friend.
All right, let's start with the issue of the conviction of Akpan, Mr. Akpan, for the murder of Iniubong Effiong, Iniubong Umoren, right? What's your opinion on the conviction, the trial itself, the conviction, the social media paraphernalia, and everything that came along with it?
Okay, my take is that justice has taken its course before it's a very serious issue which took the whole social media. In fact, it was one of the trending topics on Twitter. Twitter is one of my favorite apps I go to. Away from the social media sentiment and all, I think it's also important the court did its part by giving that matter accelerated hearing, for the reason that a lot of people were so much interested in seeing the matter coming to a conclusion really quick, because the law, justice delayed to an extent is justice denied, So on the whole, we must commend all the parties who played a great role, the courts, the prosecution, the defense, for making the matter come to a quick conclusion. So in summary, on the part of justice, people who are, they feel justice was served yesterday.
Well, this is what George Orwell once said, that all animals are equal, but some are more equal than others. Would you see this play out in the trial, the speedy conclusion of that matter? Now, there have been murder cases and armed robbery cases that are pending in the same courts, that's I quite say high courts now, some for up to 5-10 years. But this one came in and left within just a year. Now, much as we want to commend the industry of the court and every other participant in, would you feel a little uncomfortable? I mean, there are people in custody and their matter has been dragging for us up to 8 years now. Would you think Judge Owe was right in this instance?
In the instant case, my view is on obtaining, or if you want your matter to be quickly dispensed with, you need to, all parties must be serious.
Exactly.
It boils down to the seriousness of the parties, and this is one of the matters that had a lot of public interest. First, for the public interest, of course, you have a lot of matters which have a lot of public interest, but at the end of the day, they end up not being dispensed with as quickly as possible. It has to do with the parties in the matter, the states.
Or maybe the judge, the presiding officer in the case, who insists that you don't take beyond a certain number of days to come back for the trial, right?
Yes, we have judges who also say, yes, let's have or grant accelerated hearing. But at the end of the day, it boils down also to counsel in the matter. The court may be interested in hearing the matter acceleratedly. In the Uyo, a lot of judges are interested in taking up matters as quickly as possible. It also boils down to witnesses, availability of witnesses. We also have, it's a totality of maybe parties, witnesses, and also counsel in the matter.
Okay, so your opinion might be, well, because of the social media paraphernalia, this case was more equal than other cases.
No, it's the same case.
Same case.
The public opinion or public influence has nothing to do with the judge.
Okay, I want to also acknowledge the fact that on the public media, the media trial, all the accused persons were condemned to death. But when the court sat through the evidence, two were let go, right? They weren't even given any sentence. There was no count that convicted them. Would you think that was a plus to the judicial system?
I've seen a similar comment on the social media. The world now is being shaped one way or the other by the social media. You'll agree with me.
Of course.
I saw where somebody said, "Oh, why let go the father and the sister?" In my mind, I was like, what is the available evidence before this court? The court can only convict on the available evidence presented by the prosecution. If the prosecution was not really up and doing by maybe bringing available cases against the other co-accused person, I don't see a conviction on the part of the court. The court can only act on what is before it.
Well,
I cannot go outside what is.
I think personally I want to commend the speed at which this trial went through, and I'm sure the father and the sister would be very grateful to the court. The reasons being that when you're standing trial for murder, it's not bailable. Ordinarily, it's not a bailable offense. So when you are not granted bail and this matter drags forever, no matter how not guilty you are, it's presumed that you wait through the trial. And that means if it is 5 years, you would have said 5-year term or 10-year term if it is 5 years.
And it maybe some instances it turns out that you are discharged and
acquitted as it is in this case. There's no compensation for the number of years you are wasted or spent there. So they ought to be very grateful to God that the judge, in his wisdom, insisted on pulling this matter through, and they allowed it into the next legal year, which would have pushed it further down the line to September, October, November.
No, I agree with you. I agree with you. It is very commendable of the courts, of actors in the case.
All right, finally on that topic, something happened at the end of the conviction. Understand, in place of Alukutus, I wasn't in court, so if I'm wrong, please, I apologize for that. But my understanding is that at the end of it, at Alukutus stage, the convict said there were lots of people that were committing serious and heinous crimes, and they are not brought to court. That is not guilty of any offense, right? And it's a very typical thing with a Nigerian. When you are accused of an offense, rather than defend yourself, you begin to point fingers at others who you think are equally offenders, either of your own category of offense or some higher categories of offense. You know, so in this case, I hate that's what happened. I also hate that he was attempting to run out of court to escape. Were you also aware of such position?
Of course. I was within the premises.
Okay, and that's a picture of what happened?
Yes, it is. At least I've been opportune to know that was not a Photoshop thing.
Yeah, you social media people are always used to Photoshop things. I am not. All right, thank you very much. Let's move to the next item on the discussion. We are looking at this case of Inibege Fion. It's a social media trend. I think it's one of the top legal news on social media right now. A lawyer was convicted of contempt of court, Inibege Fion Esquire, and sentenced to 1 month imprisonment or in the correctional center. Now, a lot of people have come out, both legal and non-legal persons, to support and condemn the judge for the conviction and the sentencing of Inibege Fion. And chief amongst their accusation for those that are condemning him, and that he wasn't given fair hearing. The other is that he was just defending his client, and having regards to the fact that he's a lawyer on his official assignment, he ought not to have been cited for contempt. Would you share that opinion?
No. You know, what is contempt? In the context of the trendy topic, what is contempt? You know, contempt, is it in the face of the court?
Right. So there are two categories of contempt now.
Yes.
Called ex facie and in facie.
In this context, it is for the purposes of our viewers who may not really have the understanding or knowledge of maybe the Latin maxim. It is contempt in the face of the court and contempt outside the court. In this context, and in the trendy topic and the available facts, it is a contempt in the face of the court. And if you look at it carefully, there are a wide range of things that could likely make up contempt, you know.
Yeah.
But it all boils down, the justification for convicting on contempt should be that it must have brought dishonor or brought the reputation of the court, not the judge per se, but the reputation or the authority of that court to dishonor.
Yeah,
you know, brought down the reputation of the court. So, from available facts, if it is a conduct, even as a legal practitioner, you have conducts, codes and conducts. You also have rules guiding legal practitioners. One of those contained in the rules for legal practitioners is you must accord the court which you are appearing before the honor and respect it deserves. Anything that falls below that amounts to contempt in the face of that court. And that court can summarily try and convict whoever is found in contempt.
Yes, you see, the presumption here is that a lot of Nigerians are not familiar with the processes of court. We are carried away by so much emotion that we fail to see reasons or ask for reasons. Now, where a court is in full arraignment, the court is in full sitting, duly robed, the person sitting as a judge is no longer his or her person. It's his lordship, and is addressed as such. And I think it's impolite to even address him as you. So you correctly address him as the court. Because at that point, it's the dominus litis. Everything he says in that court is law. Now, when a legal practitioner begins to act in such a manner as to lower the dignity of the court, it becomes very, very scary. The duty of the legal practitioner is to promote the dignity of the court. Because legal practitioners are seen as fellow ministers in the temple of justice.
Yes.
So the court is actually a temple, and we are just serving as, I know you were not a Catholic, mass servers, right?
What if I was a mass server?
Yeah, that was a long time ago. You wouldn't even know what to do now. So you're serving as mass servers and auxiliary priests that are in the temple and assisting the officiating priests to offer the sacrifices to God. Now, in the case of the courtroom, lawyers have a duty to respect the court, stand when the court is talking to you, be quiet when the court is addressing you. If the court is not addressing you, you can't interfere or intervene even when the court is wrong. For you to intervene with the discussion of the court, it must be by express permission. My Lord, may I? And the Lord can grant you, the court can grant you leave to, or not to talk. And where it is denied, it remains silent. Now, in the instant case, our understanding is that the learned gentleman or a journalist was recording in court. The learned gentleman was doing his case fine, well and good. There were no issues, all right? Until the court cited a journalist recording proceedings without permission. And it is within the powers of the court to make any realistic and necessary punishment on the journalist. And in this case, the court said, get hold of that camera and please excuse us. Step out of the court. And the journalist quietly obeyed. But that my learned friend stood up and said, no, court, you cannot ask him to leave the court. Now, at this point, it is very necessary to explain that he was not acting in defense of his client. The transaction between the court and that journalist was a third-party transaction which did not include him. And if you stand up and ask the court to rescind his position impolitely, no matter the law that you're citing, I'm not sure any court would like that impunity. All right, beyond that, the court sat back and said, that person is out, continue with your case. And he then tied his case around the man's departure from court. If he's not back, I will not sit down. If he's not back, I will not do this. Now, what's your impression? If you were sitting as a judge, what would you do?
Okay, from the scenario you've just given, I want to add, maybe before, we all have our views and opinion.
Okay.
But what should guide our decision and view should be that first and foremost, what should guide our view should be that we should have the understanding that the judge is the master of the courtroom. He controls what happens and he controls what should happen. And those things that should happen should be within the bounds of the law. It is general knowledge that you do not allow recording in court except with the leave of the court. It is not allowed. So for a journalist to walk into the courtroom for whatever reason, whether it was video or audio, but we all have had cause to understand there was a recording, whether video or audio, you must seek the leave of the court. The court must grant that leave, it must give that leave. It is not just seeking, it must be granted. So it is very wrong for anyone to record a live proceedings without the permission of the trial judge. So if the judge in its discretion says, I will allow, that has been granted. If the judge says, no, you do not do it, counsel, proceed with your matter. You as a lawyer should not be found to be arguing with the court. There are ways which in those elementary understanding, you say you massage the ego of the court. If you need something, you come up politely to say, oh, my Lord, may I? There is this social media hype that they will say, oh, my Lord, may I? If you want something or you feel there is a need, oh, my Lord, I am so sorry. This is what happened. Oh, we needed to, it is at the discretion of the court. You do not go to engage the judge or the court in any form of argument. So it is wrong, and in the court's view, it sees it as contempt. So telling the person, walk out of my court. And also, in a second leg to what your question, you are asking if it is proper. I don't think it is proper for anybody to argue with the court, because the court is the judge is the master of its court. It decides what it wants in its court to maintain decorum and also to maintain its honor.
All right, there has been this back and forth about having security men within the courtroom. And you see, for lack of a better choice of words, ignorance is not an excuse in law. It behoves on people to ask questions to know why you had security men in the courtroom. I was in court on that day, not that particular court. And the judge said, we have been mandated by the chief judge of Akwa Ibom State not to sit for today, to observe proceedings because of the proposed strike by the Nigerian Labour Congress, NLC. But that some of my learned brothers have sat, I am sitting in chambers. I can't risk sitting in an open court. I don't know what's going to happen. But we have a circular by the chief judge that he cannot provide security for us in case anything happens. And based on that, the chief judge beefed up security within and outside the court. For the courtrooms that sat, if you wish to, security was beefed up. And maybe having regards to the fact that it could also just be rumors, he had himself properly protected. Let's have policemen sit within the court to provide extra security and comfort, if I must say, to the chief judge, that you will not be harmed in case the demonstration turns into a riot as it normally does. So now, every court, every judge has the authority and powers to protect the lives and properties of both litigants, lawyers, and judiciary staff, including himself. You know, during demonstrations of this nature, people take advantage of the rowdy nature and they attack. You remember what happened in the NSAS protest?
Yeah, I remember.
Where the courts were burnt down in Lagos with all the files and everything missing. So these are some of the things people take into consideration. These matters in court were going on. There were police officers there and weren't threatening you until you felt that there was a need to argue with the chief judge. And you told the chief judge, excuse yourself or excuse the police officers. I feel intimidated. Sometimes you must understand that when a court is sitting and you are not the most senior lawyer, you do not stand up to raise observations, because in the courtroom we work in hierarchy. So it's the most senior lawyer, the senior advocates of Nigeria, the most senior lawyer, or the bar chairman if it's in court. So when there is an observation, if the court is talking to the bar, the SAN will stand, or the most senior lawyer will stand, or the bar chairman if he's in court. Now, where a younger lawyer stands above other lawyers to complain about the crowded security atmosphere when his case is not a security risk, I doubt if the court has the need or the compulsion to respond to that complaint.
Okay, just to, you know, we are lawyers.
Yes.
In the event the most senior lawyer does not raise this observation, you are a lawyer. If you feel there is a need to maybe make an application to the court, you make the application.
By leave of court.
Yes. That is an application.
All right, gentlemen, at this point in time, we will be opening the phone lines for people to call in. The number to call will be 070-454-17707. I repeat that number, 070-454-17707. Please call in if you have any conversation to make. But be polite when you are calling in. Ask your questions, we'll get them answered. All right. So,
okay, just to get it clear, we are all trained lawyers. If you feel comfortable, I may feel uncomfortable about a thing which you don't feel uncomfortable about. So, on the issue of maybe the most senior, fine, agreed. Those are courtroom decorums. In the instant case, he may have been conducting his matter, or his matter was the one going on. So he.
Hello. 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 Hello, we can't hear you. You're on to Legally Speaking. All right.
All right, just to go ahead.
Yes,
you know, there are special circumstances. Ordinarily, you do not allow armed men into the courtroom. But there are special circumstances which you have quoted, the security situation. On the said dates, if anybody drove through the road leading to the courtroom, there were armed men all trying to be in preparation against them, maybe watching out for maybe, of course, LC was trying to.
Hello. Hello. I think we lost that caller. Please, the number to call will be 070-454-17707. For those of us that have the old number, this is the new number. All right. So you are right. Usually, younger lawyers are more proactive than the older ones. But in some courts, if you're a younger lawyer and you ask those questions, the court will only stare at you. Meaning, did you take leave? Hello?
Hello?
Yes. You're on to Legally Speaking.
Good afternoon.
Yes, good afternoon.
Am I on to Legally Speaking?
Yes, this is Legally Speaking.
Okay, my name is Joseph, calling from you.
All right, sir.
My topic is on the issue of the nuclear reform.
Okay.
Well, I don't know. It seems that the story that has been reported lastly has been lopsided, to my mind, though, from what I've seen on social media.
Okay.
I want to appreciate you for the insight, the balanced reportage you've given, because the video that the learned gentleman in the posted seemed to have admitted that he didn't know, and I don't know students. So I wonder if the honorable chief judge will just wake up and try to victimize him. So maybe those that were in court should come out and really tell us what happened, because I've also heard from one Reverend Richard, I think so, I think that's his name, that it wasn't a one-day thing, it's been going on. I think the public really deserve to know the truth on that matter.
All right.
That said, please now observe that for some time now, Legally Speaking has been fluctuating. The program has been inconsistent. I don't know. It seems like maybe you're broadcasting from the TV while the radio says now join. I want to appeal that I think this is not really working well for the listeners, because the radio joined this program by I think 25 minutes past 5. So we lost 25 minutes. So maybe the management of Planet FM should look into that. Maybe create a different time for the radio. It can be a repeat broadcast on radio. Thank you.
Oh, that's quite excellent. I'm sure the management of Planet Radio will be Up to that, then we need to have, it will be disenfranchising the radio listeners if we have a different time and they are listening to the repeat broadcast. I would have loved to call in to like you are calling in now. All right. We keep your question at bay if we have another caller, but let's tackle it headlong. Okay, let's tackle it headlong. Now, I have a colleague who said that a lawyer hid my little friend in Ebeyefio screaming from downstairs and had to go up to ask what is going on in the courtroom, that the lawyer will be screaming at the chief judge, and was part of the lawyers that went to beg the chief judge for. Hello, you want to legally speaking? We lost that call. Please, if you do well to call back, Sorry, sir. So he said he went upstairs and asked to know why a lawyer was screaming at the top of his voice in a courtroom, and realized that he was talking back and forth with the chief judge. All right. And he went in after the session with some other lawyers, and I understand the chairman of the bar too went to plead with the chief judge to rescind the decision. Yes, hello, you want to legally speaking? All right, we lost that. Now, the chief judge asked the chairman of the bar, I made a complaint to the bar against this particular lawyer. I asked the bar to caution him. Did you caution him? Was he invited by the bar to, for questioning or to caution? And the bar couldn't say anything. They acknowledged that there was a notice from the chief judge against that particular lawyer. Now, the chief judge has sanctioned him. It means it's been reoccurring. It wasn't something that happened that day. Hello, you want to legally speaking?
Yeah, I'm Mr. Ojukwu. I'm calling from Calabria.
All right, sir.
Hello?
Yes, we are listening to you, sir.
Yeah, I want to make a complaint. I had a problem with my landlord. He rejected me with armed people, beat me up. So, which appropriate people can I report this case to?
File an action against him in court.
Hello?
File an action against him and the army people in court. Petition the head of the Nigerian army, chief of the Nigerian army.
So the appropriate people, I report to the people that in authority. They say I should go back to where I come from.
File an action against him in court. Join the Nigerian army.
Hello?
File an action against him in court.
Hello?
Just go offline. Now, I was trying to advise you to file an action against your landlord in court and join the Nigerian army. If you have the names of those army officials, cite them so that the court can give you remedy. You cannot fight them. It's only the court that can give you remedy against your landlord and any other person. You can bring an action on an injunctive order restraining them for further attack on you. A fundamental right seems to be the right thing to do, because your right was impeached. So we're saying that lawyers went in to meet the chief judge after the sitting to see if he can reverse the decision. In fact, the NBA chairman came in, President Apata, sent in a delegation to see if the court can review that decision. And the court said, no, I'm functus, which is the right thing. Functus meaning, I have concluded that matter. The only other option you have is appeal. I cannot sit over a matter I have concluded. Right? Now, people also ask this question. Was that the right process of conviction? Right? Yes, let's have from you.
Okay, contempt has its proceedings, which the contemnor should be given an opportunity to defend himself. Usually show cause why I should not commit it to prison. There are instances where you are afforded the opportunity to maybe defend yourself or purge yourself of that content. For instance, you need to go into the dock to defend yourself, or maybe to show cause why the trial judge, in the face of, if the contempt was in the face of the court. But there are instances where it could happen that the contemnor says, no, I'm not going into the witness, to the dock, or I'm not going into the witness box, as the case may be. I don't want to do it. The court has the powers to summarily convict you. For instance, of course, you'll agree with me, from his post, I mean, Inibere's post, he said, I think he had said one way or the other, or maybe in the social media domain, where he was asked to derobe, to take off his wig and gown. At first, he refused. This comes to us as observers. Why were you asked to derobe? Was it, these are contributory things, or these are things that beg for answers? Of course, it could have meant go into the dock. These are not full stories. For instance, one of the callers has called in to say, no, what we heard was the other side of it. So it is proper we are guided to understand the full picture of what transpired. So the proper proceedings would have been for the contemnor, not just limiting to the case of Inibere, which the court is already functus official. There is nothing that can be done with respect. The only thing you can do is to go on appeal. Unfortunately, the Court of Appeal is on, I think they are on vacation. So there is nothing that can be done about that.
Hello.
Good evening. I'm calling from Atapa in Calabar.
Okay, sir.
I had a problem with my landlord. My landlord is ex-military. He came with army man and rejected me, threw my property out. So, so as I'm saying, so if in the house, so what will I do over this?
Person stay, and the court will charge you for contempt and ask you to extricate yourself. Hello, you're on to Legally Speaking.
Hello, good evening.
Good evening, sir.
Is this Spectrum FM?
This is Legally Speaking on Spectrum TV and Planet Radio 101.
There's a program going on there, and I've heard mentioning the name of the Chief Judge and the this other lawyer that they sent to prison for 1 month.
Go on, sir.
What ordinary people like us don't understand is, in law, right?
Hello, sir. Hello, sir. Okay, we lost that call. I hope the man can call back, because basically what we want to talk to, who we want to talk to, is ordinary people like him, so that we can help him understand how a clear picture of what transpired. So please, if you can't call back, we'll really appreciate your call. Yes, the numbers to call is 070 454 17707. 070 454 17707. That's Legally Speaking on Spectrum TV and Planet Radio 101.1 FM. Now, as we were saying, the procedure. All right, let's take the call.
Hello?
Hello.
Good evening, Spectrum FM.
Good evening, sir.
Yeah, please, in this very program, I've made to understand that sometimes you need better the lawyer that was sent to the prison did not behave well. But in the school, we were taught what we call margin of equity. Number one of the margins says that he who comes to equity must come with a clean hand. And in this academy, we are made to understand that when you are a judge, you need not have anything that will link you to any of the parties you are a judge. This chief judge is from the same place of the governor, whom he is asked to judge a case. And this very judge, the woman, knows that the barrister did not want her to be the judge in her own case because they suspected that they saw the judge in a marriage of one of the appellants of the court. Why didn't the judge stay down? Because at that point, the tendency of her being biased was 99%. Why didn't she step down? Because she now go and jail the lawyer. Whereas the lawyer knows that in nothing, the equity is the vigilance and not the indolent. The lawyer knows that that was his own right. That was why he behaved that way.
All right. Thank you very much, man, from Ikorepere. Now, in law, we don't look at the personalities. We look at the substance of the law. That judge that is from Ona and attended the wedding ceremony, or the governor attended his wedding ceremony, set aside a judgment for the same party represented by Nibe Effiong. After 3 years, no judge would do that. If she was biased, she didn't even need to show the bias. She would have just followed the law that after 3 years, Nibe ought not to have set aside that judgment and enter a full trial. But she did that. That alone should tell you the judge was not biased. Coming from your local government does not make you biased. It is the wordings of your case that shows bias. So if the wordings of the case shows that she was actually in favor of Idibere and his client, because there was a judgment against his client, and he came way out of time to beg the court to say, please set aside this judgment, let us defend this case on the merit. Everybody thought she would not set aside, but she said, no, we must do substantive justice and set aside the judgment. I did not hear anybody talk about where she came from at that point. If you file an application before the court and ask the court to recuse yourself, it is not automatic that the court must recuse himself. You must go ahead to show reasons why the court should, which is why you file an affidavit, and the other party will oppose it. If your affidavit is not weighty enough, except to say, I saw you at a wedding ceremony.
Oh, you are from the
governor's village. That's not strong enough. The court must not recuse himself on that point. You must show proper, cogent reasons. That's why in all courts, even customary courts, district court as we call it now, people file all these applications and are thrown out because you must show reasons. It's not enough to say, I had made an application for her to recuse herself. She refused to. So she's biased. No, that is not it. Thank you very much. Yeah, ladies and gentlemen.
Okay, just that would have mean what he's trying to say. Does it mean because a judge is from Akwa Ibom, he should not do Akwa
Ibom cases? Because every judge is related somehow to you, either by maternity or paternally, or you went to the same schools.
Bias must be shown. Bias is not just alleging.
Yes.
It is just not enough to say. Even this application was before the courts, which the court says, okay, let me make my records tidy.
And he agreed.
Let me make my records tidy. Like you have rightly said, obtaining judgment at pre-trial stage, which the rules of court says the application to set aside must be brought within 7 days. Then this the people went to sleep and coming back after 3 years. And this same person sets, I don't want to mention names, maybe because you say, oh, because he's the chief judge. No, whichever judge it is, it doesn't matter. But as long as you are a judge, the rule says 7 days. You know, except you must come to the court to show reasons why you want it set aside. It should be shown that you did not sleep on your rights. If this court had set aside that judgment ordinarily that would have set aside within 7 days, there is no likelihood of bias. If you feel there is bias, your application is right. It doesn't mean that you have an application automatically the court should send it or reassign it to another person. Your application, the supporting affidavit must be weighty enough, not just alleging bias.
Hello? All right, we lost that call. Now, some other thing we must say is this. When you file an application before the court, you must wait for the application to be taken. The application says, my lord, recuse yourself. And the court say, well, we have seen this application. Make my records tidy, conclude your cross-examination. So we can now take a fresh step. And you agree with the court and start the process. Then midway in the cross-examination, you say, I'm not doing it again. Recuse yourself. I will not do it again. Without showing any relationship between your recuse yourself to the case at hand, except to say I've seen you ask a lawyer, a journalist to leave the court. I'm not happy with that. So recuse yourself in my own case. That doesn't sound logical, right? It doesn't in any way sound logical. You're asking the court to recuse himself when you're already doing the matter. You had considered to do the matter. All right, let's take the last call. Hello. We lost that call.
Okay, we must also, I think it's also important to point out that the moment you see that maybe a judge understands the way your case is going, you know, they are acting, they are unbiased umpires here. But the moment you see maybe you have goofed or you have made some blunders, a lot of people will jump around to say, to accuse maybe the trial judge to say, oh, you are biased, transfer my matter, so that they may have opportunity of remedying the case. If you are the trial judge, of course you will. In some instances, you may say no, except you show me reason why I should maybe reassign or do a thing to this case. But on the merit of it, I would want to hear it. So it is not just all application that alleges bias.
That the court must recuse
itself. That the court must, in fact, grant that application. So I think there is more to it. The viewers and listeners need to understand that it is not because of the case or because of where the person of the judge comes from or where the governor comes from. Rather, what transpired, I think it is a contempt in the face of the court that made the judge to maybe order the remand of the said Inibebe.
All right, that's how far we will go, legally speaking, for today. My name remains Anthony Ebuka. I'm of Law Partners and Associates. I had with me as a guest Sebastian Udo is a legal practitioner and a social commentator in Akwa Ibom State, Uyo, specifically. Until we meet again same time next week, I hope everything you do will be legal.
The only one allowed by cross level. Our governors have to share police power with the president as stipulated by the Constitution. We do not have a federal government police force. We have the Nigeria Police Force, which shall be administered, organized, and supervised by the Nigerian Police Force.
No, my lord, I want to say something. I want to say something here. Perhaps it might also enlarge the scope of people who should be invited here for examination. My lord, if we cannot find those who literally murdered Abiola, who are those people who could be said to be the beneficiaries of the death of Abiola?
Rogers has linked you with some of the killings he did.
He never did.
He linked you with the attempted murder of Hebrew.
He did not.
My lord, the matters council is leading the evidence in our matters.
Is this an adversary proceeding?
It's not, my lord, but we can't be talking about cases which are in court.
Is this an adversary proceeding?
It's not, my lord. These cases are in court, my lord. I'm just reminding your lordship.
My lord, sorry, my lord, I think I'll be in cross-examination.
Legally Speaking, a program that deals with legal issues and questions we face as citizens of this amazing country, Nigeria. Legally Speaking. Join us every
Friday from 5 p.m. to 6 p.m.
for Legally Speaking.